Canserve Limited and the Republic of Trinidad and Tobago.
Yes, sir, Mr. Carter.
My Lord, your Lordships and my Lady have a list of representation. There's been one change.
Yes?
Jagdio Singh is not representing the first appellant here. He's been replaced by Miss Alana Rambaran. My Lord, although
Well,
Mr.
just before you begin, Mr. Carter.
My Lord, yes.
This case has been characterised by significant difficulties experienced by the registry. Various emails have had to be sent to your solicitor requesting submission of the cases. Many of those have gone unanswered. Quite apart from that, on the last occasion that your solicitor appeared before the board, he undertook to clear the court of the voluminous materials that were presented, and he failed to fulfill that undertaking, and it was discovered at the time that it should have been taking place, he was on a plane. Now, this is wholly unacceptable, and I want to make it clear that it will not be accepted again. It was only when, on my direction, that your solicitor was informed that if the cases were not submitted forthwith, that the cases and the other cases which had been listed at his specific request would be vacated, and that he would be held responsible for the inevitable costs that would have been incurred. So I hope that a clear message will go forth to him that this type of behaviour will not be accepted in the future.
Most certainly will.
Thank you very much. Yes.
My Lord, Mr. Ramlogan has delegated to me the role of speaking on behalf of both appellants.
Good.
If necessary, he will follow.
I should make it clear, Mr. Carter, that you're entirely without blame in relation to all of this.
I thought it better not to.
But I'm afraid unfortunately, because you speak, you're the medium by which the message must be conveyed.
But, my Lord, it is a burden that Council always willingly adopts.
Well, I'm not so sure about willingly, but never mind.
Well, necessarily then. Which brings us, of course, on to state of mind and intent, and the necessity of intent in the context of criminal proceedings, which are the subject of this case. My Lord, if I can start off by saying how I propose to address your Lordship. What I would propose to do, first of all, is just a few words about strict liability, what it means, what strict liability encompasses. And then go on to what it is that the Court of Appeal decided. And I will then look at the actual wording of the statute, the three sections, 212, 213, 214. And I will then discuss the authorities which deal with the general principles of statutory interpretation, and then go on to those authorities which deal with the exceptions to the general principle, including those which deal in particular with customs offences which have been cited by both parties. It seems, my Lord, by way of summary, that strict liability is not a harmonious concept. It seems to break down possibly into three different elements. Strict liability can, at its most extreme, mean absolute liability, which means that on proof of certain facts, no excuse will exonerate the defendant. Fault or absence of fault is immaterial. There's a second kind of strict liability, so-called, where what is required is knowledge of the bare facts which constitute the offence according to the statutory provision. But no further knowledge or intent is required. For example, there is no need for knowledge that the facts caused or the facts created have a particular effect or are categorized in a particular way, such as causing environmental damage or dangerous to health. And in that second category, there is no what is sometimes in criminal law called ulterior intent, as for examples in customs cases of an intent to defraud or an intent to deceive. And then there are those kinds of strict liability where once the facts are proved, the defendant is guilty, subject to there being a statutory defence provided. For example, proving that the defendant acted with due diligence or with reasonable cause. There has, in the course of the submissions in this case, been identified a lurking common law defence, which seems to have sometimes escaped the attention of the criminal courts, which seems to be that if a person makes an honest belief, query whether it needs to be a reasonable belief or not, as to the state of the facts which create the offence, the common law will provide a defence. Now, when courts therefore talk about strict liability and say that an offence is an offence of strict liability, it isn't actually much help to potential future defendants if they don't identify which of those categories the strict liability case falls. Because when we look at the statute and try and imply the canons of interpretation to the bare words of the statute, if the statute is neutral or silent as to what intent, if any, is required, then applying the presumptions which we have to apply in the case of Gammon, which of course I'll come on to in some detail, that then begs a question as to what it is that the court determines through the silence of the statutory language is a kind of liability which is imposed on the defendant. In a sense, it's easier if the liability imposed is that of full mens rea, namely knowledge of the facts which constitute the offence, and if necessary, an intent to do the acts which constitute the offence. And that, in my submission, should be the starting point. Because the consequence of having something which is below that level of interpretation and identifying that through the statutory language, Parliament being silent as to what kind of knowledge or intent is required, the court is having to write into the statute certain words which have differential consequence as to which words are written in. Is it a defence subject to proof of honest mistaken belief? Or is it that it is subject to a mistake which, if it arises on the evidence, it is necessary for the prosecution to disprove? Or is it the case that it doesn't matter how faultless the defendant is guilty of the offence and must rely upon mitigation in order to try and persuade the court not to be lenient to him?
Well, does that mean that if the statute is silent as to the mental element required, the presumption means that full mens rea must be established?
Yes, my lord, and that's what I submit. That's the starting point.
Yeah.
Now, of course, I accept that the process of interpretation doesn't stop with a presumption.
No.
But that's the presumption. If you start with a presumption, rather than starting with the statute is silent, and therefore no mens rea is implied. And I submit, and we shall look at the cases a little later.
But just to be clear,
yes,
with the statute is silent, your starting point is that there must be proof of full mens rea.
my lord, yes.
Yes. Yes.
And the reason for that is because of the need for, in a constitutional democracy, the rule of law and certainty as to what the law says, in particular in the realm of criminal law, when the consequences of violating the law are potentially very serious. And we know in this case that in certain circumstances on indictment, sections 212 and 213 carry a maximum penalty of 20 years imprisonment. And the question therefore is, how does a person who might find himself violating these particular provisions ensure that he or she does not? What is the position of the faultless importer? In my submission, the difficulty about that is that if the Court of Appeal decision is upheld, Section 212 imposes what is in effect an absolute offence, carrying with it a fine, but still a criminal conviction. According to the Court of Appeal, sections 213 and 214 are strict liability offences subject to some kind of proof by the defendant of genuine mistake. One of the problems is when one tries to encapsulate the principles into some kind of legal certainty, that the Court of Appeal was not prepared to do that and simply wanted to leave the development and the interpretation of different parts of the provisions to develop, as it said, as cases arise. Now, who is it who's going to be affected by these particular provisions? According to paragraph 83, subparagraph 2 of the respondent's case. Sorry, yes. Sorry, I'll give you a page reference. Thank you, Mr. Knox.
750. Is it 750?
Yes.
Thank you.
And this is the answer to the argument which we raise, that innocent people might be caught up by these provisions unwittingly. It says at paragraph 83, it is true that there is a wide range of prohibited items in section 45 of the Act to which section 213A can apply, but that is a matter which goes to sentence, not to strict liability. I'll deal with that later. 2, it is not entirely accurate to say that there is a very wide range of people who are likely to be involved in breach of section 213A. On the whole, it will be people involved in business as here. Well, that is potentially a very large range of business, of people. Trinidad, like England, is an island. It depends for its existence on trade. The people involved in trade are a large number of the citizens of Trinidad and Tobago. Just by way of anecdote, when I was in Trinidad a couple of years ago, involved in a public inquiry, I was staying at the hotel by the side of the quay. At least once a week, a very large ship docked there with a huge number of containers, sealed containers, which were then unloaded. The ship sailed off and was replaced by another one. That was happening week in, week out. So the few people to be affected, according to the prosecution, are the very people upon whom the economic survival of Trinidad and Tobago depend. So I'm going to ask you something which is unusual. I'm going to ask you to pity the plight of the poor criminal lawyer who is asked by general counsel.
That's present to our mind on a daily basis.
I was envisaging the situation where I was instructed by general counsel of a trading company which sold retail goods which were imported from overseas, and found himself or herself in a situation whereby the company was having to look for new markets because perhaps there were certain treaty problems arising with their relationship with their existing and trusted partners. And so General Counsel says to the criminal lawyer, look, I'm going to have to look for new markets. I have no control over how these goods are packed. I do whatever I can by way of due diligence, but I cannot absolutely guarantee that something will not be packaged among the goods which are being delivered to me, which is in violation of the customs regulations or is prohibited goods. Am I at risk? And the answer, I'm afraid, is a kind of answer that clients genuinely and understandably loathe. But it depends. It possibly depends on the nature of the goods. The more heinous the goods, the more likely it is the court is likely to find on the historical analysis that this is an offence of strict liability. It depends upon the court as to how they interpret the presumptions and the statutory wording. And you cannot guarantee that the fact that the court has interpreted one provision in one way means that another court will interpret the neighbouring provision in the same way. And so, in those circumstances, commercial activity is going to be difficult in the absence of certainty, bearing in mind the consequences of a criminal conviction to the owner or manager of commercial enterprise will be, even in any country, but certainly in Trinidad and Tobago, the possibility of business being interrupted while the goods which have been subject to, which have been forfeited or seized, are embargoed, while possibly the business activity is entirely curtailed. In an extreme case, while the businessman is in custody awaiting trial, this case took 2 years to come to finality in the magistrate's court. In the Crown Court, in the High Court, it would take even longer. Certainty is essential to all democratic life.
But I think this is slightly over-egging the pudding, isn't it? I mean, there has been uncertainty about these provisions for many years, and one doesn't hear that trade has ground to a halt in Trinidad or anywhere else. I mean, these are risks which businessmen accept and undertake, as far as I know. I mean, this is also anecdotal, so how much does it help us actually on this task?
Well, I'm simply putting myself in the position of what kind of assurance can a businessman have? The argument goes both ways, of course. It is said that following fees, the case of fees in Trinidad, that nothing untoward happened. There was no influx of prohibited goods as a result of that decision, which said there should be mens rea. It might be said that in the absence of any evidence that Trinidad's commercial life has stopped, my argument is a purely hypothetical one, which indeed it is. But it is, I submit, a legitimate one.
But shouldn't we get on to actually looking at the authorities rather?
Yes, certainly.
I mean, my part,
The anecdote, if that's not a euphemism for giving evidence, is very interesting, but I think, as my Lord says, probably we'd better address the actual issues in this case.
Can we then turn to what the Court of Appeal actually said, because they made a different finding as to the Section 212 compared with Section 213 and 214. And it's in Volume 2 of the record, at page 601.
well, the audience seem to have been more interested in your anecdotes than getting on to the law.
I'm grateful for any small success.
Yeah.
Yes, 601.
At the conclusion of the Court of Appeal, in paragraph 28, the wording of section 212A omits the word knowingly before makes and subscribes or causes to be made and subscribed any false declaration. Applying Patel, in the absence of the qualifying word knowingly, all that is required to prove the offence of making and subscribing a false declaration was proof that the entry in the customs declaration form was erroneous. The offence under section 212A of the Customs Act is one of strict liability, and no proof of mens rea on the part of the respondent is required. Thus, the magistrate erred in concluding that section 212A required proof of knowledge. So what the Court of Appeal there is deciding is that the offence in section 212A is an absolute offence. That's what they seem to be saying.
Well, is that right? Because you've still got to have the intention to make the declaration. So what they're saying is that mens rea is not required in relation to one element
I'm sorry, yes, that's
the
right.
offence.
The knowledge of falsity is not required.
Yes.
So the act of a deliberate act of making the entry is the actus reus that's required. And whether you say that the mens rea is implicitly involved in subscribing the words or your signature to a declaration, then of course I accept that to that extent it's required. But their encapsulation of strict liability means that in the context, for the purposes of section 212A, the fact that you do not know that the declaration is inaccurate is immaterial. So far as sections 213 and 214 are concerned, the Court of Appeal dealt with those together. And at page 636, at paragraph 94, sorry, I should in fairness start with paragraph 93. It should be carefully noted that the concept of mistaken belief referred to in paragraph 92A above is not entirely synonymous with and is somewhat narrower than the defence of mistaken belief which applies in criminal law. However, it is not within the domain of this judgment to elaborate any further on this issue in the abstract, as cases rise dependent upon their precise factual context. There will be the need for elaboration in due course. So what they're saying there is that insofar as there is a persistent common law defence of honest mistake, that will apply, but not the kind of knowledge which they say was suggested by the accused. 94, in light of the foregoing, we're of the view that the presumption of mens rea has been displaced. So in other words, they'd applied the presumption and they'd found that it was displaced, thereby making the offence of importing prohibited goods and importing or exporting goods not corresponding with the relevant entry under sections 213 and 14 of the Customs Act strict liability offences. The isolated factor of the progressive strengthening of the penalties under that section does not overshadow and overwhelm the cumulative effect of the other factors considered in paragraph 68 to 85 above. He, Corte, is incapable of being distinguished, having regard to the type of criminal offence that was there under consideration, as well as extreme seriousness of the maximum penalty that was there involved. And further, the decision in Brown illustrates the factor of the seriousness of the penalty, while undoubtedly important, is not necessarily conclusive for the purpose of evaluating whether the offence is one of strict liability or not. And then in 96, the magistrate erred in finding that sections 213 and 14 of the Customs Act required proof of knowledge, and in concluding that the charges against the respondents under those sections had not been made out. Accordingly, the respondents ought to have been called upon to answer the charges against them. So, to that extent, in those sections, strict liability means simply that offences of importing or exporting goods, which in fact do not correspond with the customs manifest, the entry provided to the customs, is sufficient to constitute the offence. And possibly subject to a positive defence being raised of honest, possibly honest and genuine mistake. So that's where we are. And that's why I say, I'm afraid that's why I did give the suggestion about trying to put yourself in the position of people who are affected by these provisions. That the reality of a criminal prosecution is extremely serious for anyone, but particularly for the business community, given the timescale effectively involved and what it can mean to the conduct of business life. So now let's look at the wording of the sections. I think so we can you give me a page reference? I'm sorry, my lord, because we've between us we've set out the wording of the sections in various places. So
well, Mr. Knox is suggesting it should be in the respondent's case. Is that right?
Yes, as an exhibit. Fortunately, it didn't for some reason get into the electronic bundle, but it is an exhibit to the hard copy. It should be behind either tab 1 or tab 2. You have the Customs Act.
if not, they're incorporated into both the case of the appellant and of the respondent.
Not the full text, unfortunately. I think we have to go to the annex to the respondent's case in order to see the full text of the sections.
Well, why don't we do that? The respondent's case begins at 724.
It's not in the electronic bundle.
It's not in the electronic bundle. It's
Is it not?
the hard copy. It's the only place where we've got the full text.
But I'm told it's not in the electronic bundle. It's only in the hard copy.
Yeah. Can I hand up these? Let me give you a copy to Peter. Do section 2 and 2. In this bundle, you need to turn towards the end to page 103, the pagination on the top right-hand side.
Another good reason for the timious submission of cases, Mr. Carter, this really should be in the electronic version. Yes. I operate entirely from the electronic version, and it's extraordinarily inconvenient for me to have to revert to the paper copy. And I'm not alone in that experience, so let me reinforce the message that I hope that I sufficiently emphasised at the beginning of the hearing. Anyway, let's go. Where are we going to?
Page 103, section 212. So we're going to look at the actual wording of the statute which creates the offence which is the subject of the appeal.
Yes.
So 212, and it's subsection A, of course, or paragraph A, which is the section with subsection with which we're concerned. Any person who, in any matter relating to the customs or under the control... Sorry, my lady.
Page you're on. Could you just repeat it?
103.
103, my lady.
Of the
that piece of paper.
Thank you.
Sorry, I'm afraid it demonstrates just how inconvenient this is, I know.
Thank you. Pardon me.
Yes.
A person who in any matter relating to the customs or under the control or management of the controller makes and subscribes or causes to be made and subscribed any false declaration, or makes or signs or causes to be made or signed any declaration, certificate or other instrument required to be verified by signature only, which is false in any material.
In any particular, yes.
Yes, and then we go over, shall incur a penalty of $125,000, which, of course, I accept in the context of many criminal offences is not very much, particularly bearing in mind the exchange rate. But so that's the offence with which we're concerned. Now, of course, it's necessary, sometimes helpful, sometimes not, to look at what the other paragraphs within the same section provide by way of comparison or contrast if necessary. B, makes or signs any declaration made for the consideration of the controller or any other application presented to him which is untrue in any particular. C, being a person required by the customs laws to answer questions put to him by any officer, refuses to answer such questions or answers untruly any questions put to him by an officer acting in the execution of his duty. D, counterfeits, falsifies or willfully use when counterfeited or falsified any document required by the customs law or by the controller or required to be submitted to the controller under any other law or used in the transaction of any business or matter relating to the customs. E, alters any document after it has been officially issued or counterfeits the seal, signature, initials or other mark of or used by an officer for the verification of any such document or any other purpose in the conduct of business relating to customs and so on. And F, on any document required for the purpose of the customs laws or required to be submitted to the controller under any other law, counterfeits or imitates the seal, signature or other marks, whether or not with the consent of the other person. And this is an example, I submit, of the limited value in which comparing the wording of one part of a section with the wording of the section which is the focus of the court's deliberation can lead to. Because what we have there is, in paragraphs A and B, there's no indication of a requirement of knowledge of falsity or intent to deceive or intent to make or produce anything false. C is consistent with a requirement that the person answers untruly in the sense of tells lies, but that may be equivocal. D, counterfeits, falsifies or willfully uses, mens rea. E, alters any document or counterfeits the seal, etc. Again, I would submit mens rea. And F, counterfeits or imitates the seal, etc. Again, mens rea. Now, the difficulty is over the years, courts have differentiated about their approach to this. Sometimes they've said that in the absence of the word willfully or knowingly or intentionally in part of a section, where it appears in other parts of the same section, that omission is deliberate and indicates and can only be construed as indicating that this is a strict liability offence. Other courts have said, no, that doesn't follow. And the fact that the word knowingly appears in one part of the same section or another part of the same statute doesn't actually help when you're construing the presumptions that must be applied, and also looking at it as to whether this is a truly criminal provision, given the nature of the offending or the act which is prohibited and the penalty to which the person offending is to be subject. What I would submit is that the use of the word knowingly in paragraph A, in a sense, would be tautologous, and that's why it's not there. Because a person who makes and subscribes and causes or to be made any false declaration, which is false in any particular, I would submit that implies within itself an intention or a knowledge that what is being done is not simply the addition to a document of a signature or a fact, but the knowledge of the falsity of the fact which the document contains.
Well, a document or a declaration can be objectively false, can't it? It doesn't require the subjective intention, necessarily, of the person who is making or subscribing to it.
I agree. But looking at this subsection, not looking at the word false in isolation, but looking at it in context, what here this provision is dealing with is a person who smuggles. And the Court of Appeal said that these offences are about smuggling. That connotes, I would submit, an element of fault and deliberation.
Well, the contrary argument is the contrast between A and D, whereas D requires counterfeits, falsifies, or willfully uses. Falsifies, one can understand, connotes a deliberate intention on the part of the person who's preparing the document to make a declaration which he or she knows to be false. Whereas in A, there's no similar provision at all. Anyway, let's go on from that.
That's in fact the distinction which the Privy Council drew in Patel, isn't it?
It is, yes.
Between false and falsify.
Yes, and I submit they were wrong. But yes, that's true.
You're coming on to that.
Can I deal with sections 213 and 214 first?
Yes, absolutely. But you're coming
But
back.
I'm coming to that, yes. What I'm going to do after I looked at the wording of the sections is come to the presumption provisions and then look at cases like Patel. So 213 is similar in the sense that A prohibits makes a person who imports or brings in or is concerned in importing or bringing into Trinidad prohibited goods or restricted goods. B, unloading. And then C, knowingly harbours. D, knowingly acquires possession of. E, is in any way knowingly concerned in fraudulent evasion or attempt at evasion. And again, the same issue arises. Is the omission of the word knowingly deliberate in the sense of intended to make this a strict liability offence, or is it presumptively implicit within it and does not require the word knowingly, as is required for the following subparagraphs where it applies? In the sense,
well, why on earth would the legislature deliberately include the word knowingly in 3 of the subparagraphs and omit it in the first 2?
Well, it might be because those whose conduct is ancillary to the main part of producing for the customs purposes a declaration, or those whose activity is subsidiary to the actual importation and handling of the imported prohibited goods. It may well be that in those cases, their ancillary contact with the goods is remote, and therefore knowledge is required, where it is assumed or presumed that the person who imports or makes a customs declaration has full knowledge of the facts about which the customs declaration is the subject. And therefore it makes perfect sense in my submission for the subsection to be silent as to the requirement of knowledge for the person who imports or makes the declaration, whereas those who have ancillary association with the declaration or with the goods themselves has to be proved knowingly that these goods are prohibited or that the declaration, etc., is false.
I don't understand that on the facts, because if you're the importer, the container will have been packed in the exporting country.
Exactly.
Not by the importer, so he's not likely to know.
But not necessarily when this statute was produced.
Well, I think that must always have been so, wasn't it? Whether the goods were put in a container or simply wrapped in brown paper.
Yes, well, I agree that there is that possibility, yes. But at least there is therefore the assumption that the importer, or presumption, that the importer does know what the importer is importing.
I think my latest point is, how could he? That's the point. I mean, if he's not involved in the actual packing up of the goods, how could he be knowingly importing? In all manner of things could be put in the material that he has sought to import. And that's why, in a way, it makes perfectly logical sense that the strict liability, or the absolute liability, however one wants to describe it, applies to A and B, but C, D, E, and I think F, all of which the individual has control over, does require knowingly.
Well, it may make semantic sense, my lord, I agree with that, but it doesn't make sense in the context of due process or legal certainty. Because yes, that's the problem, that if this statute was intended to make criminal the activities of an honest importer who had no means of knowing that somebody was intending to secrete within a legitimate consignment some prohibited goods, is it really coherent with constitutional rule of law principles that such a person should face a potential penalty of 20 years imprisonment and have, on the face of it, no means necessarily of establishing any defence?
Well,
because that is the conclusion, and that is why the presumptions, I submit in Gammon, which I shall now come on to, my lord, why the presumptions in Gammon are so important, to make sure that the provisions of a statute which are silent, insofar as they are silent even as to one particular of a section, whereas they're not silent as to another, why the presumption applies in order to prevent the law affecting and biting and chiding those who should not be the subject of criminal sanction. 214 is in very much the same terms, so unless you want me to, I'm not going to.
Yeah, I don't think that's necessary.
So what I'm going to start with then is a case of Gammon. Historically, I suppose I should start with sweet and parsley, but I'm not going to go through historical
Well, you can take
narrative.
the sweet and parsley, it's very well known to.
Well, it is, and it's dealt with in Gammon, so there's no point me dealing with it twice.
Right.
So Gammon is in volume 4, page 893. If you have yours tabulated, it's at tab 4, otherwise it's page 893.
Yes.
This is about building regulations, breach of building regulations. And looking at the head note, that the facts aren't particularly relevant to us, it's a principle that matters. The presumption, this is on page 894, the presumption that mens rea was an essential element of a statutory offence could be displaced by clear and by necessary implication, where the statute creating the offence dealt with an issue of social concern, including public safety, provided that strict liability would be effective to promote the objects of the statute. That since greater vigilance would be promoted if knowledge of the materiality of the deviation from the plan was not a necessary ingredient of the offence, subsection was to be construed as requiring knowledge of the deviation from the plan, but imposing strict liability for the deviation being a material one. So knowledge of the critical fact was a necessary ingredient of the offence, but knowledge of the consequence was not. Similarly, provided the appellants had knowledge of the manner in which the works were carried out, they committed an offence under the subsection, even if they did not know that there was a resulting risk of injury or damage. And Lord Scarman delivering the decision of the board, if we turn please to page 897,
Yes.
cited the relevant passages from Sweet and Parsley. It is firmly established by a host of authorities, this is at letter D, the general law, that mens rea is an essential ingredient of every offence unless some reason can be found for holding that it is not necessary. So the starting point for section 212, 3 and 4, paragraph A, in each case, the starting point is that the essential ingredient of every offence is mens rea unless. So the fact that it is capable of having that interpretation is not sufficient. The fact that it makes semantic sense is not sufficient. There must be some real necessity as to why, ignoring the surrounding noise, if you like, of the other subsections, why is it that mens rea is not required for this particular offence?
Well, I suppose it might be said that there is a good reason that mens rea is not required to be proved, because the packing up of the material to be exported is outside the control of the importer in conventional circumstances. And therefore, the defence that the importer was unaware of what was put in the consignment to be transferred is an easy one to raise and a difficult one to refute. Whereas if you've got control of the materials once they've come to their destination, then it makes more sense that a requirement of mens rea should be imposed, because then there can't be any question but that the importer and those who deal with the goods when they arrive must know what the consignment contains.
That's a pragmatic issue, but it then begs the question.
Pragmatism sometimes informs principle, I suppose.
I'm sorry, my lord, I wasn't intended to be critical.
No, of course not.
But the question then is, what is the necessity and what is the justification on a rule of law principle of saying that the person who, by pragmatic definition, cannot know that prohibited goods are in the consignment he is receiving, is thereby guilty of an offence simply by acting and trading honestly, and unwittingly finds that in the goods that he has no intention of dealing with, but he finds, or customs officers find, there is an illicit part of the consignment?
Well, I'm sorry, I obviously didn't make the point sufficiently clearly. The point is that let us suppose that there is someone who arranges for contraband material to be placed in the consignment, but he has no control, no direct control over that. If it is required to prove that he had mens rea, that is a defence which is easy to raise and difficult to disprove. You're asking us to consider the situation where he has absolutely no knowledge of it, and that, of course, is one way of looking at it. But the dispensation of the requirement to prove mens rea covers a wide spectrum of circumstances beyond the entirely innocent individual who has no knowledge of the adventitious insertion into the consignment that he has ordered of contraband goods. It covers also the situation where he is complicit in that, but you can have resort to a defence of lack of requisite knowledge. And the point is surely that if you're considering a situation where he has taken receipt of the goods when they've arrived at the destination, then it's entirely logical and principle to say it must be shown that he has mens rea at that point. But, on the other hand, it's logical not to require proof of mens rea when he can raise the defence that he had no control over what was put into the consignment. In this case, may I exemplify the distinction?
I've got two answers to that.
Yeah.
The first is a statute or wording one, language one. If that were the position, if it were intended that, that somebody who could not control the importing or the placing of illicit goods in his consignment is to be made guilty, then it would be perfectly easy for Parliament to say, unless he first, as soon as he is aware of the prohibited item, he notifies officers or the control of Customs and Excise. Because at that stage, he would be in the same position of the subsequent handler of the goods, and would thereby have knowledge and would be under an obligation, it might be said, that in order to avoid criminal responsibility, that person must notify the controller, have nothing further to do with the illicit part of the otherwise legitimate consignment. That's the first point. The second point, my lord, is that the history of convictions for importations of prohibited items, certainly into the United Kingdom, demonstrates that however sophisticated the methodology used, there are means by which the officers of Customs and Excise are able to demonstrate, and do repeatedly demonstrate, that the person responsible for importing them did so knowing that that illicit item was included within the cargo. So it is possible, it is not sufficient to say it is difficult for the prosecution to be able to overcome the defence. The reality is, time and time again, sophisticated attempts to violate the customs prohibitions are defeated by intelligence, by investigation, and by simply finding that these goods are there and then looking into the background, telephone evidence, cell site evidence, documentary evidence. It is not difficult in reality.
It might be possible to do it in that way, as does the United Kingdom, but isn't the question we have to decide what is the intention behind this particular legislation? And
it is.
What method was to be used here?
Yes. So
there may be differently held views, legitimately held, as to the appropriate approach.
Before I answer that, my lady had a question.
No, I was just going to say, where was the evidence to show this? That it was easy to convict, but that's a separate issue.
Yes, it is.
Yes, quite. Right. Anyway,
but what it means
let's take that on faith at the moment.
Yes. What it means is then that Parliament must have decided deliberately that it's better to, pour en corriger les autres, to have people who are entirely innocent being prosecuted for an offence with a substantial penalty in the event of conviction, with the possibility that they might be able to establish that they were genuinely had no knowledge.
Yeah.
Whereas compared with other offences with similar penalties, with similar kind of social stigma, it is accepted that mens rea of the knowledge of the presence of the prohibited item is a requisite of the offence.
Mm-hmm. We do have to inhabit the real world, of course. The prospect of contraband being inserted into a consignment, quite unbeknownst to the importer, does perhaps stretch credulity a little far.
Well, I agree.
Yeah.
Yes.
However,
that's a factual matter. Yes,
yeah.
that's a fact.
Let's move on.
And it actually means that in those circumstances, proof is easier. But I'm going on with Gammon, if I may.
Yes, of course.
At paragraph F of page 897, Lord Scarman continued, looking at the ordinance, it's necessary to have clearly in mind the applicable principles of the criminal law. 3 cases, all of them well known, bear directly on the issue. He then cites Shiraz and de Rutsen, a case under the Licensing Act, in which Mr. Justice Wright prefaces judgment, this is at letter H now, by a statement of general principle at page 921. There is a presumption that mens rea, an evil intention or a knowledge of the wrongfulness of the act, which is what I'm asking for in this case, is an essential ingredient in every offence. But that presumption is liable to be displaced either by the words of the statute creating the offence or by the subject matter with which it deals, and both must be considered. Then he cited at the top of page 898, Lim Chin Aik and the Queen. And it went on to say, second line at letter A, the board warned that the adoption of the principle does not dispose of the question whether the presumption is displaced, for the difficulty of applying the principle remains. What should be the proper inference to be drawn from the language of the statute under review? What are the inferences to be drawn from the subject matter with which the subject deals? And then he cites Sweet and Parsley. Where the subject matter of the statute is a regulation for the public welfare of a particular activity, statutes regulating the sale of food and drink are to be found among the earliest examples. It can be and frequently has been inferred that the legislature intended that such activities should be carried out under conditions of strict liability. The presumption is that the statute or statutory instrument can be effectively enforced only if those in charge of the relevant activities are made responsible for seeing that they are complied with. When such a presumption is to be inferred, it displaces the ordinary presumption of mens rea. Can I just pause there, my lord, to comment that I submit that implicit in that proposition is a principle that displacement happens when the person upon whom strict liability is placed is capable of taking responsibility for ensuring that the prohibited act does not take place. The board went on, Lord Scarman said, now letter E, where it can be shown that the imposition of strict liability would result in the prosecution and conviction of a class of persons whose conduct could not in any way affect the observance of the law, their lordships consider that even where the statute is dealing with a grave social evil, strict liability is not likely to be intended. Therefore, I submit, based upon that principle alone, that looking at the provisions of section 212, which it might be said is not so serious, obviously isn't as serious as 213 and 214, but let's concentrate on 213 and 204. I would submit it cannot be said that even though importation of prohibited goods is a grave social evil, it cannot be properly inferred that strict liability was intended to be imposed upon people who were innocent of the knowledge that what was being imported were prohibited goods. Lord Scarman went on, however, in Sweet and Parsley, Lord Reid refused to accept that in determining the question of mens rea or strict liability, it is sufficient merely to have regard to the subject matter of the statute in construing the words of the provision creating the offence. Other considerations have to be borne in mind, including the nature of the prohibited act. If it were truly criminal, it would be necessary, for example, to consider whether the public interest really required that an innocent person should suffer in order that a few guilty men might escape. And then he cited this passage, G, but where the subject matter of a statute is a regulation of a particular activity involving potential danger to public health, safety, or morals, in which citizens have a choice as to whether they participate or not, the court may feel driven to infer an intention of Parliament to impose by penal sanctions a higher duty of care on those who choose to participate and place upon them an obligation to take whatever measures may be necessary to prevent the prohibited act without regard to those considerations of cost or business practicability which play a part in the determination of what would be required of them in order to fulfil the ordinary common law duty of care. But such an inference is not likely to be drawn, nor is there any room for it unless there is something that the person on whom the obligation is imposed can do directly or indirectly by supervision or inspection, by improvement of his business methods, or by exhorting those who may be expected to influence or control, which will promote the observance of the obligation. Just pausing there. There are occasions in which turning a blind eye can be used as a route to knowledge. So, for example, importing goods from a supplier about whom you have serious concerns is certainly the footing for an inference of knowledge, of deliberately taking the risk that what is to be included in your legitimate cargo is something which you don't want to ask about. And that would be sufficient to satisfy the mens rea element. Going on at page 899, in their Lordship's opinion, the law relevant to this appeal may be stated in the following propositions. And here we have the 5 propositions that Lord Scarman set out. There is a presumption of law that mens rea is required before a person can be held guilty of a criminal offence. The presumption is particularly strong where the offence is truly criminal in character. The presumption applies to statutory offences and can be displaced only if this is clearly or by necessary implication the effect of the statute. The only situation in which the presumption can be displaced is where the statute is concerned with an issue of social concern and public safety is such an issue. Even where the statute is concerned with such an issue, the presumption of mens rea stands, unless it can be shown that the creation of strict liability will be effective to promote the objects of the statute by encouraging greater vigilance to prevent the commission of the prohibited act. It has not been, cannot be shown that strict liability will have that effect in this case. And by way of guidance of the application of those 5 propositions, if I can refer to page 900, letter H, and the final paragraph on that page. Whether, therefore, a particular provision of the statute creates an offence of full mens rea or of strict liability must depend upon the true meaning of the words of the particular provision, construed with reference to its subject matter, and to the question whether strict liability in all respects or any of the essential ingredients of the offence would promote the object of the provision. As to that, all you have is the assertion of the state. It might have been helpful had there been any kind of material before the magistrate, the Court of Appeal, or this board, which gave any foundation to such a proposition. Lord Scarman then went on to deal with how you interpret the fact that there are different provisions or provisions which are capable of being construed to create different kinds of mens rea or liability. At page 902, letter B, and it's a paragraph beginning the second feature. The second feature, in their Lordship's opinion, proves nothing. And that's the provision about the fact that different provisions or different wording. Sorry, I'll start again. Make sense of this. Top of the page. Second common feature is that each provision appears in a section which creates many other offences. The wording of some, though not all, of which clearly requires full mens rea. Sorry, it serves me right for trying to summarise Lord Scarman when I should have quoted his actual words. The second feature, in their Lordship's opinion, proves nothing. One would expect a wide range of very different offences in a statute which establishes a comprehensive system of supervision and control over a great range of complicated works in diverse circumstances. And it can be said with equal force that a feature of Section 40 is that in many cases where mens rea is required, it expressly says so, and that where a defence or reasonable excuse or lack of knowledge is to be available, it makes express provision to that end. Examples may be seen. But the severity of the maximum penalties is a more formidable point. But it has to be considered in the light of the ordinance read as a whole. For reasons which the Lordships have already developed, there is nothing inconsistent with the purpose of the ordinance in imposing severe penalties for offences of strict liability. The legislature could reasonably have intended severity to be a significant deterrent, bearing in mind the risk to public safety arising from some contraventions of the ordinance. Their Lordships agree with the view on this point with the Court of Appeal. It must be crucially important that those who participate in or bear responsibility for the carrying out of works in a manner which complies with the requirements of the ordinance should know that severe penalties await them in the event of any contravention or non-compliance with the ordinance by themselves or by someone over whom they are required to exercise supervision. But what they found was, in that case, in letter G, the provision applies to building owners, and then fourth line down, there is plainly an element of mens rea in the offences it creates. The wording of subparagraphs A and B does not make clear how far mens rea extends. The wording of subparagraph C reveals an offence of full mens rea. And then at letter H, the wording of subparagraph B clearly requires knowledge of the approved plan and of the fact of deviation. But in their Lordship's view, it would be of little use in promoting public safety if it also required proof of the knowledge of the materiality of the deviation. As it was put on behalf of the Attorney General, if the offence requires knowledge of the materiality of the deviation, the defendant is virtually judged in his own cause. So, knowledge of the fact, not knowledge of the consequences. So it wouldn't matter, for example, although it is an arguable ground, it is capable of complying with the 5 propositions that sections 213 and 214A are construed as requiring knowledge of the presence of prohibited goods within the cargo. It is not necessary, I would suggest, for the prosecution to have to prove the precise nature of those prohibited goods. By way of alternative, it would be sufficient for the prosecution to prove that the knowledge of those goods, not necessary to prove that the defendant also knew that those particular goods happened in law to be prohibited goods. So you have 2 alternative routes to a conviction, but you only have one route to a defence, namely you do not know that what is in the cargo consists of goods which are in fact prohibited. Knowledge of the fact, or absence of knowledge of the fact, is therefore to be presumed as an essential element. Makes sense. Knowledge of the fact is an essential element that must be proved.
An appreciation that they are or are not prohibited goods is simply a failure to know the law, isn't it?
I agree. Yes.
It can't be a requirement.
I don't think so. There are certain circumstances in which it might be said, knowing that it is in contravention, but that isn't the law, that isn't the section here. And so we needn't construe a section with which we're not concerned. I agree. If it happens to be in violation of the law, the fact you don't know that, well, that's your own lookout. And particularly if you're an importer, you ought jolly well to know.
Might I just ask you a question about section 213, subsection B?
Yes, my lord.
Which again doesn't have the word knowingly expressly in it. What I'm trying to understand is how broad is that particular that particular paragraph? If you assist or in any are otherwise concerned in unloading the goods which are prohibited. I mean, for example, would that apply to the person who controls the crane, which is going to lift the container off the ship?
My lord, if you construe A as imposing strict liability,
Yeah.
in the sense the Court of Appeal found, then B would apply to the stevedore.
Yes. But your submission is that B is in fact a broad scope and would encompass persons to whom the imposition of strict liability would not have the effect of promoting the objects of the statute, because
Yes.
they're not in a position to do anything about it.
Exactly.
Yeah, I understand. Thank you.
So that's why I submit that A and B must be, it is sensible to construe them in the context of the remainder of the section. I know that isn't particularly telling, but it is of assistance to understand that if those who are, maybe the people who are the organisers have to know because they're adjectively concerned, with the importation, but at arm's length. If proof of knowledge is required on them, why on earth is it not required for those who actually are involved in a much physically, in
a more peripheral way?
Yes.
But isn't this precisely the point the Court of Appeal left open at 92 paragraph A? Because they're saying there's a defence for honest merchants. And then they say later, over the page, that they're not going to refine that because it's not necessary to do so in this case. Sorry, it's, I beg your pardon, 635 to 636.
Yes, the central question then is if there is an ingredient of mens rea, is it mens rea required as part of the offence, or is it something which comes independently of the interpretation of the offence and provides a defence, but a freestanding matter, not implicit within the construction of the offence itself?
Yes. But the stevedore, if one were content with the defence for the moment,
Yes.
would prima facie be able to look to paragraph 92A, and then it would be a question for the court to refine that. But the type of activity you've described is somebody who's a very long way from the person with whom one might suppose the statute was concerned.
My lady, I agree with you. I agree with your proposition, yes. And this is why it ought to be obvious that such a person should not be caught by these criminal provisions.
Your submission is that you shouldn't have to look to a defence. You shouldn't be included at the outset.
The acquittal of the innocent has implicit within it, as part of our, it's one of our overriding objectives in the criminal procedure rule, the acquittal of the innocent should have implicit within it that the innocent should not be charged in the first place.
But if he was raising the defence, it would be simply a question of his raising a prima facie case?
That's something that the board will have to determine. That if it is a defence as opposed to implicit necessary within the definition of the offence, he is required to raise the defence. The question is, do you use the Wilmington provision? And Wilmington says that where mens rea is a necessary ingredient of the offence, then the defendant doesn't have to raise honest belief as part of the defence. It can be raised during part of the prosecution case. And therefore, if the evidence consistent with honest belief emerges in the course of the prosecution case, and the prosecution are not able to disprove it, then a submission of no case would succeed. Whereas if the obligation is on the defendant to raise the defence, and possibly the burden to prove it, and this is a question that the board will have to consider, is it an obligation to raise and prove, or raise and for the prosecution to disprove? Because the Court of Appeal doesn't deal with that.
But isn't there a general principle that unless otherwise indicated, it will be a prima facie case only because of the burden on the prosecution?
Normally, the principle is, if there is a burden imposed upon a defendant, unless the wording of the statute says otherwise, then it is sufficient for the defendant to prove on the balance of probabilities. Or, in some cases, as with Section 45 of the Modern Slavery Act, to raise the evidence, which then imposes on the prosecution the legal burden of disproving. But I'm afraid these things are not altogether consistent.
Well, it's a question of adducing evidence sufficient to raise the issue, is that right?
Well, that's the first point, yes.
But when it comes to the question of the grant of, or the acceding to an application for no case to answer, even where it's incumbent on the prosecution to disprove a defence raised by the defendant, all that the prosecution has to do at the time of the application of the submission of no case to answer is to establish a prima facie case. Isn't that right?
That's correct, my lord, yeah. So that is why it is important, therefore, to look at the different stages and identify whether the absence of knowledge is necessary for the prosecution to prove as the mens rea element, as opposed to the distinct freestanding defence, generally applicable, of absence of knowledge, which, if raised, either has to be disproved by the prosecution or there's a burden on the defendant to prove it, depending upon the construction.
Right. Well, I think we're probably sufficiently exhausted there. I'm sorry.
Forgive me, could I just raise one point? You did say twice, Mr. Carter, this is a matter which the board will have to decide. But in fact, what has happened here is that in paragraph 92, the Court of Appeal has referred to the possibility that there is maybe available a defence on the lines of Fraley and Charlton. It's also referred to the possibility of a wider defence of genuine mistake, a road that's not been followed in the jurisdictions in the United Kingdom and not been followed yet in Trinidad and Tobago.
That's correct.
As I understand it. Those possibilities are floated. They're left there. There's no cross-appeal in respect of that, as I understand it. Is it a matter we've got to decide?
Well, what I would like you to decide is that there is mens rea required, and that's full knowledge.
Oh, quite. I think we understand that.
I understand that.
Yes. But what I would submit is that if the board decides that this is a case of what you might call strict liability light, that there is a possibility of a defence by establishing or raising the issue of mistaken belief, honest belief.
This is my question. Is it in the scope of the appeal? Because the Court of Appeal did not decide the point. It didn't consider it necessary to decide the point.
They did not, no.
No. And therefore, my Lord's question amounts to this. Should we be troubling ourselves with it? Not least because if the Court of Appeal hasn't expressed a final view on it, it would be slightly untoward for us to decide the issue as an academic question when we haven't had any input from the local court.
Much as I would like to persuade you to give guidance on that, I can see that actually constitutionally there is a problem about you providing a ruling on something which is not strictly before you.
Right.
And therefore what I would invite you to do, if you come to this, is to consider that it is an issue which requires to be addressed and would therefore have to be remitted to the Court of Appeal for them to address.
They've indicated on the very next page that they regard this as something they would have to address in an appropriate case.
Yes.
Right, well, let's move on then.
Can I next refer you to the case of, it's an English case, B and the Director of Public Prosecutions. It's in volume 4. It's at page 764. It's the first tab.
Yes.
This is a case of unlawful, an act of gross indecency with a person under the age of 14. And the head note says that the conviction was quashed. Mens rea was an essential element of every criminal offence unless Parliament so expressed, Parliament expressly and by necessary implication provided a proposition with which we're familiar. Page 796. Lord Nichols dealt with the common law presumption at paragraph F. So the presumption, the propositions following from Gammon based upon sweet and parsley. As habitually happens with statutory offences, when enacting this offence, Parliament defined the prohibited conduct solely in terms of the prescribed physical act. Section 1, subsection 1 says nothing about the mental element. In particular, the section says nothing about what shall be the position if the person who commits or incites the act of gross indecency honestly but mistakenly believed that the child was 14 or over. In these circumstances, the starting point for a court is the established common law presumption that a mental element traditionally labelled mens rea is an essential ingredient unless Parliament has indicated a contrary intention, either expressly or by necessary implication. The common law presumes that unless Parliament has indicated otherwise, the appropriate mental element is an unexpressed ingredient of every statutory offence. And then he cites the passage in Sweet and Parsley. And over the page, letter B, under the heading reasonable belief or honest belief, the existence of the presumption is beyond dispute. But in one respect, the traditional formulation of the presumption calls for re-examination. This respect concerns the position of a defendant who acted under a mistaken view of the facts. In this regard, the presumption is expressed traditionally to the effect that an honest mistake by a defendant does not avail him unless the mistake was made on reasonable grounds. And then the citation from the case of Tolson from 1889. Common law and honest and reasonable belief in the existence of circumstances which, if true, would make the act for which a prisoner is indicted an innocent act has always been held to be a good defence. And just pause there. That rather begs the question, doesn't it? When is an act an innocent act? Does it mean morally innocent or innocent as a matter of law? Because if you have the type of strict liability offence, which is known as an absolute offence, then there is no innocent act. So mistaken belief would not avail you. So innocent belief as a defence is only going to apply in that category of strict liability offences which are not deemed to be absolute offences.
That's a sort of circular proposition. If they're absolute, because there is no defence of honesty.
It is entirely circular, yes, it is.
Well, is it going to help us then?
Well, it does to this extent, that if that's the conclusion to which you are led, it's one which I suggest you ought to think very hard before you regard that as a proper construction of the provision.
Right.
Going down to F, the letter F, Lord Nicholl cited again from Sweet and Parsley, and repeated that it's a general principle of construction of any enactment which creates a criminal offence is that even when the words used to describe the prohibited conduct would not in any other context connote the necessity for any particular mental element, they are nevertheless to be read as subject to the implication that a necessary element in the offence is the absence of belief held honestly and upon reasonable grounds, which, if true, would make the act innocent. And therefore I construe the use of the word innocent to mean effectively not worthy of criminal punishment.
Yes?
And then going on to page 798, letter C. Considered as a matter of principle, the honest belief approach must be preferable. By definition, the mental element in a crime is covered with a subjective state of mind, such as intent or belief. To the extent that an overriding objective limit on reasonable grounds is introduced, the subjective element is displaced. To that extent, a person who lacks the necessary belief, intent or belief may nevertheless commit the offence. When that occurs, the defendant's fault lies exclusively in falling short of an objective standard. His crime lies in his negligence. A statute may so provide, expressly or by necessary implication, but this can have no place in a common law principle of general application which is concerned with the need for a mental element as an essential ingredient of a criminal offence. And the traditional formulation of the common law presumption, exemplified in Lord Diplock's famous expedition in Sweet and Parsley, is out of step with this recent line of authority, insofar as it envisages that a mistaken belief must be based on reasonable grounds. This seems to be a relic from the days before a defendant in a criminal case could give evidence in his own defence. It's not surprising that in those times juries judged a defendant's state of mind by the conduct to be expected of a reasonable person. And then onto the element of seriousness, the seriousness of the offence or the conduct which is made the subject of the criminal offence and the consequences. And that's at starting at page 799, letter H.
Yes.
In section 1, subsection 1 of the Act of 1960, the Sexual Offences Act, Parliament does not expressly negative the need for a mental element in respect of the age element of the offence. The question, therefore, is whether, although not expressly negatived, the need for a mental element is negative by necessary implication. Necessary implication connotes an implication which is compellingly clear. Such an implication may be found in the language used, the nature of the offence, the mischief sought to be prevented, and any other circumstances which may assist in determining what intention is properly to be attributed to Parliament when creating the offence. I venture to think that, leaving aside the statutory context of Section 1, there is no great difficulty in this case. The section created an entirely new criminal offence in simple, unadorned language. The offence so created is a serious offence. The more serious the offence, the greater is the weight to be attached to the presumption, because the more severe is the punishment, and the graver the stigma which accompanies a conviction. Under Section 1, conviction originally attracted a punishment of up to 2 years imprisonment. This has since been increased to a maximum of 10 years imprisonment. The notification requirements under Part 1 of the Sex Offenders Act 1997 now apply, no matter what the age of the offender. Further, in addition to being a serious offence, the offence is drawn broadly, an act of gross indecency. It can embrace conduct ranging from predatory approaches by a much older paedophile to consensual sexual experimentation between precocious teenagers, of whom the offender may be the younger of the two. The conduct may be depraved by any acceptable standard, or it may be relatively innocuous behaviour in private between two young people. These factors reinforce, rather than negative, the application of the presumption in this case.
What do you draw from all of this?
That the two things. First of all, that the way in which the offence is stigmatised is an important part of the interpretation and the question whether the propositions, the presumption, have been displaced. Secondly, an increase in sentence, in the penalty provided, can give added weight to the application of the presumptions, even if at one stage the presumption might have been equivocal or difficult to be certain about. Once it becomes a truly criminal offence with a serious penalty, which might impact upon those whose moral blame is marginal, then it becomes necessary to interpret the provision as having full...
Well, do you say that that has any relevance in this case?
Yes.
In what way?
Well, if there is a risk that person...
There has been an increase in penalty
Yes.
in this case. How does the current penalty compare in terms of value with that which was originally enacted?
It's gone up considerably to the potential for 20 years imprisonment. I think it was 3 years originally. Yes, it started off with financial penalty, as with Section 212.
But in terms of the financial aspect of the possible penalty, what is the pro rata comparison between the time that it was originally imposed and its current level? Well, if you need to
yes.
think about that, you
Yes.
can come back to it later.
I must haven't particularly addressed that because of the
Right.
incidence of inflation as well. As a
That's
consequence.
exactly what I'm getting at.
But inflation doesn't have an effect upon imprisonment.
Quite.
But I mean, it seems very odd that the same wording in the statute should acquire a mental element merely because of changes in the penalty.
Well, I submit that it doesn't, my Lord, of course. I submit that the increased penalty indicates that Parliament regards these offences as serious. But even if...
I mean, I find these very difficult. I mean, it seems the idea of the case about the sort of thing that was in issue in B minor has anything to do with statutes about importation seems to be fairly far-fetched. If one asks about the relative criminal stigma of what this boy was doing and what your clients were doing, it seems to be a simply impossible comparison.
Well, it's a matter of principle, my lord, as to whether an offence which has very serious consequences upon conviction and a stigma as well, whether they fall within the general category of offences to which the presumptions must apply. And it doesn't matter whether the nature of the offences, it's the consequences to the offender that matters.
But are you arguing that in its original conception, this may have been a strict liability offence, but because of the increase in penalty, it has been transformed into an animal of different hue?
That is a possible interpretation.
Well, is that not contrary to authority, that one decides on whether the offence is one of strict liability at the time of its enactment, not by recourse to development since it has been enacted?
Well, no, my lord, it depends upon whether you go back and take a purely historical view as to what is the origin of the statute, or how the perception of the offending has changed as the legislation has been amended, and whether the legislation is treated, as Lord Steyn described it, as a living instrument, a speaking instrument, which one hopes listens as well as speaks.
So
and
that
therefore
actually changed the mental element of the offence by increasing the penalty.
Yes.
Without any adjustment to the actual terms of the section?
Yes, there would be no need to do that. No necessary need to do that. But we know, don't we, that trying to read into the minds of Parliament by looking at the distinction between the wording of one section and another is not really the route to statutory interpretation which the courts must apply. The courts have to go beyond what they can try and identify from the mere wording of the provisions. And the purpose of the application of the common law principles is to use rule of law principles to apply, enforce, and make sense of provisions which Parliament sometimes makes it difficult for us to understand and construe consistently or coherently.
Well, do I understand your submission to be that at the time of original enactment, it was not intended that these should be strict liability offences? But if we don't accept that, we should conclude that because of the increase in penalty, if they were originally strict liability offences, they have been transformed into a condition where mens rea is required to be established. I see. All right, now let's move on then.
How exactly was the penalty changed? Was it by a statutory instrument?
It was by amendment to the statute.
Primary legislation?
I think so.
Yes.
Yes.
Thank you.
Right.
I'll just make one point, perhaps I needn't refer to particular provisions to say so, or case law to say so than by a reference. I'm aware of the time. It's sometimes said that the presence of a discretionary sentence is sufficient to reinforce an interpretation consistent with strict liability. The difficulty about that, of course, is feeding back into the question of legal certainty, that discretion cannot be anticipated. In Trinidad, at least, there's no equivalent of the Sentencing Council. The discretion of a prosecutor to exercise leniency is not a substitute for an interpretation of the law which requires mens rea to be applied to be part of a serious offence to prevent the need for the discretion to be exercised, because otherwise wholly innocent persons will be caught within the net of the criminal offence.
There are 2 points there, aren't there? One is the discretion of the prosecutor.
It is, yes.
So, and the other is the discretion of the judge in passing sentences.
Yes, it is. So I accept there are two distinct parts. The discretion of the prosecutor would of course be subject to judicial review. But again, that is not of great help. And the discretion of the sentencer will be subject to the appeal courts. But if an offence of strict liability is construed as being created by sections 213 and 214, then any sentencing judge would have to say, Parliament has decided that in the absence of fault, this offence carries a maximum of 20 years imprisonment. And so I must look at the mitigation in the light of that maximum sentence. Parliament has not, as it could have done, created a categorisation or differential penalty depending upon proof of knowledge or absence of negligence or absence of due diligence. It could have done that, and that would have made perfect sense or made more sense if it was going to say liability will be imposed irrespective of knowledge. But in this case, it hasn't done that. And so the risk faced by a prospective defendant, by a prospective importer, is all the greater. So I make that point, but I'm not going to go into it in any greater detail. Can I come on to Patel then, please? Because Patel is obviously the buffer which I must remove, in a sense. It's in volume 4 at page 1009, tab 9. Now, this is an offence which is identical in all material respects to section 212. And I'm confronted, I accept, by the reality that in the same way as a court of appeal, in the language that they used in delivering their judgment, distinguished between section 212 on the one hand and sections 213 and 214 on the other. And I acknowledge that although there was an argument below that the three sections should be construed as a unity, there are strong reasons for saying, because of the wording of them, because of the penalty imposed by them, that they actually can fall into separate categories. So I'm faced with that possibility. Because the sentence for section 212 offence is a fine, no imprisonment, and therefore one can see that different considerations as to the presumptions and propositions apply as between the two sets of offences. Anyway, Patel was an offence equivalent to section 212. And at page 110 of the bundle, the head note, the appellant imported from Singapore into Fiji a quantity of coriander seed, shipped in bags and correctly engrossed the customs import entry form in accordance with the particulars contained in the invoice referable to the purchase of the seed. So factually...
Sorry, what's the electronic page number, please?
Page 1010, my lord.
Thank you very much.
Factually, pretty much on all fours with this. On investigation at arrival, 5 bags were found each to be contained in an outer bag marked with the appellant's trade name, but the inner bags had written on them something else. And at the base of them, the legend producer Morocco. In the import entry form, the country of origin was stated to be India. The appellant was charged with making a false declaration in a customs import entry produced to the officer of customs, contrary to the local section 166. In other words, the false declaration as to country of origin. Over the page, held allowing the appeal, so I should say the magistrate found there was no mens rea and acquitted. Supreme Court allowed an appeal by the prosecutor and convicted, and then it went to the Privy Council. Allowing the appeal that on the true construction of section 116, it was an absolute offence to make any false customs entry, and therefore mens rea was not a necessary ingredient to the offence with which the appellant was charged. and the fact that the alleged false entry was made without any intention to deceive the customs authorities afforded no defence. Not all the offences contained in section 116 would be constituted unless mens rea were established. So again, it might be said and will be said similar to R3 sections. That was the only evidence purporting to show that the entry was false, the only evidence purporting to show that the entry was false was the legend produce of Morocco written on the bags, and the words from an evidential point of view were inadmissible against the appellant as hearsay, the list of exceptions to the hearsay rule, etc.
That was the reason the appeal was
That was the reason. So having found that it was an offence of strict liability, what they found was that the evidence constituting the actus reus, namely the port of origin, was hearsay, and therefore there was no sufficient evidence to demonstrate that there was any falsity. But in doing so, they managed to say that this is a defence of strict liability. Can I draw your attention, please, then to page 1016. I should acknowledge that on page 1015, at letter B, Lord Hodson, on behalf of the board, said, "The first question is an important one which frequently arises upon the construction of statutes. The general principle of the common law, if a matter is made a criminal offence, is that it is essential that there should be something in the nature of mens rea. There are, however, exceptions to this rule in the case of quasi-criminal offences, as they may be called." And then onto page 1016, letter C. It is to be observed that section 116 itself contains a number of offences set out consecutively and joined by the conjunction or. It is sufficient to say that some of these would plainly require to be construed so that no offence would be constituted unless mens rea were established. For example, the words, "should any person counterfeit, falsify, or willfully use when counterfeited or falsified," words which we've seen elsewhere, would not in their lordships' view be satisfied in the absence of proof of mens rea. It does not, however, follow that all the phrases in the section must be read in the same way. And the making of a false entry may well be in this, as in other similar statutes relating to customs, absolutely prohibited within the exceptions to the general rule applicable to statutes creating criminal offences. So what the board is saying in Patel is absolute. The distinction must be a narrow one. In considering the various parts of the section, if the conclusion is correct, that one cannot falsify without a guilty mind, but that one can innocently make a false entry. Notwithstanding the narrowness of the distinction, their lordships are of opinion that this difficulty must be faced. In my submission, I regret to say that that was not properly facing up to the force of the propositions required by Sweet and Parsley and by Gammon. A narrow distinction is not the proper way to result in the construction of a criminal statute so as to result in the absence of mens rea.
Yes.
And the absolute nature of the decision in Patel is reinforced at page 1018 at letter B. Where, having considered on the previous page the case of Lim, Chan, Aik and the Queen, which we saw referred to earlier, at letter B, they are of opinion that the decision of the learned judge in giving the opinion of the Supreme Court, that's in that instant case in Patel, as to the meaning to be assigned to the word false is correct, and that on this point the appeal would fail, since the offence of which the appellant was convicted was absolute and no proof of mens rea was required. Now, that is not what the respondent is submitting in this case. The respondent does not submit that even section 212 is an absolute offence.
That's a very limited. Our position is this: you can always imagine extreme cases where it would be, it couldn't have been the intention of Parliament to make someone guilty. That's the short point, and I'll develop it later. But I do accept that there may be very extreme examples you could give of an entirely luckless victim who's done everything conceivable, and someone slipped in some drugs 5 minutes away from the port. You can imagine all sorts of cases like that. And it's not my case that it would necessarily bite even in those circumstances. That will be a matter for another day.
Thank you. Yes, Mr. Carter.
The respondent's case is that relying upon the existence of what's called a common law supervening defence of honest, genuinely held belief is applicable in all cases. But that is not what Patel said. And therefore, insofar as they rely upon Patel as being an authoritative guide to interpretation, that cannot be correct. So either they live with the consequences of the case of Patel and accept that the interpretation which the Court of Appeal applied and which they seek for has unintended consequences for the genuinely innocent, or they accept that Patel must be revised so as to accommodate an escape clause. And if that escape clause is one of two forms, I submit it's mens rea. The prosecution submit it's some kind of writing in to sections 213 and 214 at least, and possibly 212 as well, writing in subject to the defendant establishing honest belief or honest mistaken belief. And the question I pose is why write that in rather than writing in the obligation of the prosecution to prove the absence of honest belief, given the normal presumptions which apply to serious criminal cases.
The reference to the Australian authorities at page 364,
Yes.
they're in line with Patel, are they?
I'll go back to that if I may.
Sorry, that's page, electronic bundle, page 1017.
The wording of those statutes isn't identical. The basic point they make
Yes.
is always the same.
Yes.
But I think the wording is given on the previous page.
I think in the Australian cases it's different wording.
But in Patel,
Sorry, can I just finish that? I mean, is that right? He refers at 1016 to the Australian statute, and then he relies on what's said by Dixon, CJ and Sternberg and other state decisions. He seems to think those as being consistent with what he's decided.
He seems to do, yes.
So there appears to be a sort of fairly common thread
Yes.
running through. I mean, there may be minor differences of wording, but there's a common thread running through the Commonwealth authorities.
There is. What's happened is what I might call a degree of slippage. What seems to happen is that the propositions and the principles, the guiding principles are periodically stated, and then the courts find a series of exceptions. And so then the guiding principle, as in the case of Kay, for example, has to be restated to remind courts that actually these are the fundamentals, the starting points of our interpretation. And it's a bit, if I might use the analogy, it's a bit like having a valuable tapestry which is periodically nibbled by moths. And so we see what was a marvellous fabric is then being undermined by a series of what are apparently pragmatic decisions on particular facts and particular provisions. And if we go back then and actually look at them, the historical decisions on individual cases, I submit, are of limited authoritative value.
I think my lady had a question.
Thank you. I'd rather choose the analogy of the Sydney Harbour Bridge, which moves in accordance with the necessity of the time. And if you can find in 363, letter E, some argument, I would just like your views, that when Lord Hodgson refers to absolute liability, he means absolute liability according to the, apart from the exceptions in the common law from time to time. He says absolutely prohibited within the exceptions to the general rules applicable to statutes creating criminal offences. So he's using absolutely in the sense that sometimes the word strict is used in relation to liability. So he's not ruling out absolutely the possibility of some offences.
I'm so sorry, you're absolutely right.
Thank you.
I'm so sorry. I should have read that. Yes, I missed it. I'm sorry.
Right.
I was going to refer to the case of Kay, in which Lord Steyn reinforced the position of the presumption, but again, it's simply reiterating the same proposition and reiterating that the displacing of the presumption is only relevant or is only appropriate in case of necessity.
Yes.
Can I deal with then with one of the authorities which the Court of Appeal decided to effectively reinstate below? The case of Glendon de Gale, which is tab 5 of volume 4, starting at page 905.
Yes.
This deals with section 214 of the Customs Act. And on page 906, we find in the middle paragraph the facts which were illicit goods which had been included among another cargo. Similar to this case, on page 908, middle paragraph, a no-case submission was made contending that it was not established that the defendant knew or should have known about the illicit consignment. And page 909, the magistrate dismissed the charge on the basis that the respondent had no knowledge of the items which are the subject of the charge. And the court then went on, that finding leads to the real issue in this case. It turns upon the question whether the words of section 214, taken in connection with the general scheme of the Act, should be read as implying that a person, before he can be convicted under the section of importing any package containing goods which do not correspond with the entry thereof, must know or have reasonable means of knowing that the particular goods were in the package at the time, or whether the section amounts to an absolute prohibition against submitting an incorrect entry, no matter how innocently done, for goods which he has imported. A principle long recognised in criminal law that a person should not be convicted of a crime unless a guilty mind could be imputed to him has been over the years significantly tempered by legislation which has imposed liability for something done quite independently of there having been any guilty mind. I infer from that that the statute has explicitly so stated. and we're aware of such things in other jurisdictions as well. Where an Act of Parliament states without any qualifying words that the doing of an act is to create liability, the state of mind in which the act was done is irrelevant. On the other hand, it has often been said that if an act contains an absolute prohibition against the doing of some act, as a general rule, mens rea is not an ingredient of the offence. Next paragraph. It is not a simple task to reconcile the many authorities, but the effect of them seems to be that where the act imposes what is apparently an absolute prohibition, an absence of scienter may or may not be a defence. It appears that in every case much depends on the wording and purpose of the particular act. And examples are given of Hobbes, and then further down the page of Shiraz. Turning over to page 911, the middle of the page, second main paragraph. Turning to the relevant sections, 213 and 214 in this case, they appear to derive their genesis from the United Kingdom legislation on the topic, as do most similar statutes in the Commonwealth countries. Authorities from that jurisdiction and from those countries in the Commonwealth which have corresponding legislation have been useful in assisting the court to reach its conclusions in this case. The sections deal mainly with offences in relation to goods imported into or exported from this country. The mischief these sections intend to deal with is, no doubt, inter alia, the prevention of smuggling. So there we have it. In fact, previous legislation relating to customs identified similar sections under the heading Regulations for the Prevention of Smuggling. In the Act before this court, the marginal note to sections 213 and 214 is to the same effect. I just interpose there. Of course, we know that marginal, what is in the margin of a statute is not of any guidance, but is there simply for information. I shall deal with section 213 first, and then it's read out. One significant feature of this section is that in 3 of the 5 offences, there is used different language regarding persons who import or unload. It's the distinction with which I started off my submissions to you this morning. And the 6 lines up at the end of the line, the inclusion of the word knowingly in respect to the last 3 offences and its omission in respect to the first 2 lends to the view that any person charged with the first 2 offences is to be subject to absolute liability. There is, however, a diversity of judicial opinion on this interpretation of the absence of the word knowingly in offences of this nature. The court then refers to Meha and Shiraz and goes on in the second paragraph on page 913. It is difficult, therefore, to extract from the authorities the proper rule applicable to those subsections of section 213 where the word knowingly is not used, although it is not necessary for the determination of this case. I submit that if the presumptions are applied, it no longer becomes difficult. It becomes very easy. And the court simply says that the words in subsection 213, 214A, and if it ever becomes relevant in any case, B, include the words knowingly, by necessary, by implication, by presumption, and are not displaced by necessary implication.
The passage on the previous page, which you read just at that moment, at 911, and I know you're short of time, was there any thought given in this case to whether there would be legislation in Commonwealth countries which are from which appeals go to the CCJ rather than to the Privy Council? Whether there was any assistance for this board?
I have to ask Mr. Ramlogan about that. No.
No, there wasn't any.
Shakes his head, no.
Thank you. No consideration or no help?
Neither.
No consideration.
Ah, yes.
Just by going on page 915, the second paragraph, if I can paraphrase it. Legislation in describing the offences in 213 has described the need for scienter or mens rea by the use of the word knowingly in the following subparagraphs, and by its omission of the word knowingly in the offences under A and B, appears to have made those offences absolute offences, as in Barber. While it is not necessary to determine the point, when one considers the mischief which section 213 seeks to avoid, the mandatory provision that the goods in question are to be forfeited, and the obvious influence of the execution or perpetration of certain acts by their very nature, are in the total control of the person who brings the goods into the country. It may be, if the legislation is to have a positive effect, that it is necessary to prohibit the acts absolutely. But query, is it, if what is imported is not within the total control of the person who is subjected to this absolute liability? Page 920 of the same authority in Patel. Having considered in the previous case, the case of St Margaret's Trust, and a third line down on page 920, in rejecting the contention on appeal that the order should be construed so as not to apply where the prohibited act was done innocently, in other words, that mens rea should be regarded as essential to the commission of the offence, the Court of Criminal Appeal held that having regard to the object of the financial control of which the order was part, its contravention was an offence, although the act was innocently done. This case demonstrates that punishment of conduct, which is the result of blameless inadvertence, is not in itself a sufficient reason for concluding that the relevant legislation was not intended to impose strict liability. But what kind of consideration must there be to impose strict liability in such circumstances, and strict liability with the consequences which these penal provisions contain? The Court goes on, the offence in this case before this Court is similar in all respects to the offence in Patel and Western Electric, as far as the submission of a false entry is concerned. Like Patel, there's a marked absence of any words such as knowingly or with intent to deceive in the ingredients of this offence. But that does not necessarily lead me to the conclusion that mens rea is not required. It is that in the context of which the offence has been enacted, and the very exacting penalty of forfeiture which it imposes, the section achieves what it sets out to do, and that is to prohibit absolutely the submission of an entry which is under the sole control of the person importing the goods, which does not correspond to the goods which have been imported. Sole control. And the Court in this case is saying, looking at the differential wording, that wouldn't necessarily have resulted in the same. But what matters is the context in which the offence has been enacted. Prohibit a person importing the goods which are under the sole control of that person. And so the conclusion on that basis, at page 921, second paragraph, in my judgment, therefore, after reference to Dean Roscoe Pound, in my judgment, therefore, I hold that the requirement introduced to the section by the learned magistrate was wrong. That's a mens rea interpretation. There was no onus on the prosecution to establish that the respondent knew or ought to have known that the goods in question were in the packages. The offence is one of strict liability, and upon proof that the respondent had imported the goods and the entry submitted by or on behalf of it was erroneous, the offence was complete. Any construction of the section which would involve the addition by implication of the word knowingly cannot, in my view, be sustained. Attorney for the State submitted that even if the offence was not an absolute one, and it was necessary for knowledge to be established, that knowledge had been established.
Well, do we need that?
We didn't deal with that. Yeah, sorry. So that is the authority which the court below, sitting as a three-judge court, and of course I give deference to the fact they sat as a three-judge court, in order to consider whether they were prepared to divert from the decision of fees, which had apparently overturned Patel. And what the court below decided was that it preferred Patel to the decision in fees, which required mens rea, and what had been in force for several years. Sorry? Glendon, I'm so sorry. Glendon, yes. Thank you. It's almost time I gave up. And in doing so, in my submission, when one looks at the wording of the case, of that case, the Court of Appeal were wrong to do so, and in reality they applied the wrong test. I said I would deal with the decisions which had dealt with importation. Most of those actually are simply illustrative, and I've dealt with the principle, so I don't think I need to deal with that. In a couple of minutes, there's one issue which remains, and that is the question of identification for the purposes of corporate liability. If I can deal with that very quickly. Salomon and Salomon is cited, but is simply the historical backdrop. It's Tesco and the Truss, which is the main authority. There's a distinction between vicarious liability and direct liability. Some statutes, by express wording, impose on a corporation vicarious liability. This does not. The only liability which can attach to Canserve is direct liability. Direct liability can only be achieved by demonstrating that a person who represents the company truly as its directing mind or will, or a person to whom full authority has been delegated by the company, has committed the act. There is no such evidence in this case that insofar as an offence was committed by Mr. Nurse, he had that authority. No doubt he was acting as an agent of the company, but not in that capacity. And therefore there was no sufficient evidence that Mr. Nurse was a directing mind of the company, or had delegated to him by those who were the responsibility for doing this act as the company's representative, not simply as an agent or a manager of the company.
If the offence is one of strict liability, you accept that there's vicarious liability?
I do indeed, yes. And can I say, because part of the, I haven't addressed, it's not just because of lack of time, I haven't addressed the respondents' arguments about the evidential basis for a finding which would have justified a finding by the magistrate of no case to answer. I accept that if there is a finding that these offences are absolute, subject to the supervening general defence of proof of lack of knowledge, then there was a case to answer.
Thank you. Well, I think your time is up, Mr. Carter.
Thank you, my lord.
Mr. Ramlugan. Thank you very much indeed. Now, Mr. Noakes.
My lords, could I just say a few words by introduction? I submit the underlying error in the appellant's case is that if you can show that strict liability in relation to an offence would in some circumstances be totally unreasonable, You would then move to the opposite end of the spectrum and say that the prosecution must prove guilty knowledge in all aspects of the offence. I say that's just wrong. If I could say why it's wrong. First, it is not the case that if strict liability applies on one aspect of the offence, then strict liability must apply on all aspects of the offence. Take, for instance, Section 213. What about the instance of a man who has drugs planted on him as he walks through the airport? Now, my lords, it's not my case, and you'll see why later, that he would necessarily correctly be found guilty under Section 213. What about, for instance, someone who is forced to sign, might be a slightly extreme example, a declaration form under duress? Is he deprived of that defence? And so forth. There are all sorts of possibilities which don't arise on the facts of this case, where it may be that the court would say, well, there's not a strict liability offence in that respect against that type of fact. Secondly, I say there are many different gradations of mens rea, express or implied, especially in cases involving the collection of revenue and the importation of goods. I submit that there is very good reason for holding that you are liable unless you happen to be a luckless victim of someone else's wrongdoing, or alternatively, you acted honestly and reasonably. But there is no warrant, in my submission, in offences of these types to say you move to the opposite end of the spectrum and the prosecution must actually prove guilty knowledge. That is to say, for example, you filled in the declaration knowing it was untrue. My lords, take that as a simple example. It obviously would be, one would have thought, the intention of Parliament that if you fill in a declaration as to what the goods are and their value negligently, then you should be liable. On the face of it, one would expect that. Thirdly, I say the distinction between the actus reus and mens rea, which is implicit in the notion of characterising certain offences as those of strict liability, disguises a very important question which straddles those two issues. And that, of course, is the question of causation. Because whether or not an accused can be said to have done something, or indeed caused an act, will often depend on whether or not he was at fault. And again, one might take as an example the man who has drugs planted on him without any knowledge on his part at all as he walks through the airport checkout. Has he brought the goods in? Well, depends on how you define bring goods in. That in turn depends upon causation. Or take an example more pertinent to this case. What if my supplier, who I totally trust, I have no reason to mistrust whatsoever, he has an impeccable record, for some reason he decides to defraud me and send totally the wrong goods to me. Well, I have absolutely no way of stopping that through myself, my agents, or anything. Well, my lords, one can see in that type of case. Query, does the strict liability rule
there must be
apply even
authority
that far?
on that. I mean,
sorry?
I would have thought in that case, if you cause them to be brought in, you cause them to be brought in. I mean, whether you knew what they were doesn't seem to affect the word bring.
Well, my lords, the statute defines import, I'll take you to it later, as bring in or cause to bring in. Now, there may be, my lords, it's not my submission that in this case you should finally decide what is the position of the entirely luckless victim who has done absolutely everything in his power to ensure that the right thing comes in, through himself and his agents. And my lords, I'll come to the decision in Lim Chin Aik, which is an important decision, which lays down a general principle that, on the whole, you don't interpret statutes as seeking to find what is called a luckless victim. So if you've done absolutely everything you possibly can through yourselves and your agents, then, on the whole, the courts will say it's unlikely that the statute intended to impose liability, even in those extreme circumstances.
Well, in the circumstance that is an exception to the rule, what is required of the defendant? Simply that he raise the issue?
Well, he's got to adduce some evidence of it.
Yes, but in order to raise the issue, he's got to adduce some evidence.
Oh, yes. He can't just sort of wander around.
No. But he raises the issue through, for instance, cross-examination.
And getting evidence out.
And getting evidence out.
Yes.
And then it would be for the prosecution to disprove it beyond reasonable doubt?
Yes, my lord. My lords, my lady, that is certainly the way what you might call the lim chin aik exception seems to work.
I'm sorry, my lord had a question.
Yes, I can understand, Mr. Knox, why you refer to lim chin ike, because it makes your overall position more attractive. But we don't have to decide this point about lim chin ike, do we?
Well, my lords, you don't exactly have to decide it, but it's implicit in the Court of Appeal's reasoning, because what my learned friend is saying is look at all the unreasonable consequences of strict liability, to which I say, well, no, as indeed the Court of Appeal recognised, we're not deciding all types of case, and one can imagine other very hard types of case where a court might take a different view.
We're left in the difficult position that the Court of Appeal didn't decide the point, and said it didn't arise and didn't need to decide the point.
Well, my lords, that's because one has to look at the actual facts which the Court of Appeal was considering, against which it made its judgment. And my lords, my position is that when you look at the nature of the facts and issues against which the Court of Appeal made its judgment, it's plainly right to say that this was, quote, an offence of strict liability, in which the prosecution did not have to prove fault.
Yes, but I think my lord's point is, why should we take it upon ourselves to embark on an examination of the availability of a possible defence when the Court of Appeal has disavowed that opportunity themselves?
Well, my lord, the reason being this, my learned friend says, if it is either an offence of almost psychopathically absolute liability, or else you go to the other end of the spectrum and say that the prosecution's got to prove guilty knowledge. My point is there are lots of gradations in between absolute liability or totally psychopathic strict liability, and on the other hand requiring imposing far too lenient.
Your argument is that we don't have to accept that it lies at the polar opposite ends of the spectrum, but beyond accepting that there are gradations, is it necessary for us to lay down, or would it be sensible for us to attempt to lay down a prescription as to when it might...
No. In my submission, certainly not. All it would be sensible to do would be to say, against the facts of this case, the Court of Appeal correctly held these were offences of strict liability. And one therefore needs to look at what were the facts, or more precisely the issues in this case, to see whether the Court of Appeals got it right. It's not an entirely academic question. I agree you shouldn't seek to answer entirely academic questions, but the question for you is, was the Court of Appeal correct in saying, given the facts of this case, or the issues in this case, were they correct to say that these were offences of strict liability? Because, my lords, it's implicit in my submission that you can't decide all the possible variations which might arise in any given case. All you can do is look at the facts and issues in this case and say, was the Court of Appeal's decision correct?
It might be thought that it was important for a court to decide whether one of these two different defences is actually available. And that might have an important bearing on this, but it seems to me we're placed in a very difficult position because the court below didn't decide it. Expressly said that it was not going to decide it. It didn't need to decide it.
And my lords, the other point, of course, this is all on a no case to answer submission, so we don't quite know exactly what the defendants were going to say.
Well, that does create a difficulty. But let's suppose we were to consider that it was open to the defendants in this case to bring themselves within that exceptional position of having done all that could reasonably be expected of them. Then is the only alternative open to us, if we accept your argument, to remit the case?
Well, my lords, the Court of Appeal don't deal specifically with that argument against the facts of this case. They just say it doesn't arise on the facts of this case, but there would be other types of case in which it might arise.
The difficulty is the magistrate, having granted a no case to answer application, one theoretically, I suppose, doesn't know what defence the defendant...
But one does. It's very much my point, that there was absolutely no defence whatsoever, whichever way you cut this case. But that's a different matter, if I may say.
Right.
But can I just say what the issues were before the magistrate?
Yes.
And on the importation charge, it was expressly accepted that the defendants intended to bring in gambling machines. And their defence was, oh, I didn't realise they were prohibited, which is hopeless. And the magistrate thought it was all right, I think. And secondly, they weren't all put together so as to operate as gambling machines. And the Court of Appeal said to that, well, that's obviously wrong. So, my lords, the position we're standing in at the moment in relation to Section 213, the importation charges, I say it's very difficult to see what defence there is, bearing in mind the issue is run at trial.
Right.
I mean, in one sense, one wonders, it could be said, the Court of Appeal didn't have to go as far as they did in saying this was an offence of strict liability, except to cut out, I suppose, the possible defence of, I didn't realise these were prohibited items. And my lords, in relation to the two declarations, the defence was, well, that was just a mistake, that I filled in office furniture rather than gambling machines. Now, I suppose it's possible it was a mistake. Assume for the moment it's all a big mistake. One can ask the question sensibly on this appeal, well, would a mistake of that sort run as a defence to the charge? Just, goodness me, I don't know what happened when I filled that form in. And so, my lords, those, I submit, strictly speaking, are the issues which you can decide, and I submit what you might call the lim chin aik exception, or the Lord Diplock sweet and parsley exception, you don't really have to get into, although I have gone into in my case, but I submit, in fact, those are quite straightforward issues.
Except to say that they exist.
Except to say they exist. And my lords, obviously, one of the concerns which we have on our side is that one moves from this almost psychopathic strictness to a great leniency, and completely missing out what we say is an old common law doctrine, which obviously has application in offences, regulatory revenue type offences. Well, you are liable unless you can show or raise reasonable doubt that you acted under an honest and reasonable mistake of fact, which would have justified you in acting as you did. Now, that defence has been rather submerged, as a matter of, in the law since 2002, but in my submission that's as a result of a misunderstanding of what was decided in essentially an indecent assault case in 2002. But my submission is it is still there, that defence, and it has never been knocked out.
It's not referred to in Gammon at all, is it?
Gammon, say the Tolson defence, or the Lord Diplock sweet and parsley defence. I'm not sure it is, no.
Which, I mean, I'm getting rather confused.
Forgive me, my lord,
What
yes.
is the best and clearest authority for the defence that you are saying exists and has never been submerged?
Well, it starts with Mr. Justice Stephen in Tolson, in the 19th century decision in Tolson. Yes. And then it is reiterated by Mr. Justice Devlin in a case called Reynolds in 1951. Lord Diplock expounds it in full in Sweet and Parsley. Yes. And it's then noted in passing by Lord Gough in a case in 1992 called Pharmaceutical, I can't remember the full title, Pharmaceutical something, and Storkwain.
And it's
Pharmaceutical Society, I can't remember.
Against?
Storkwain. It's then also accepted as a possible caveat on the importation offence itself in Jamaica, which is in very similar terms, by the Privy Council in a case called Simmons. And so it has a distinguished ancestry. And I should say it's universally accepted, it seems, throughout Canada, Australia, and New Zealand.
And
it's never been accepted in the United Kingdom jurisdiction.
Not with the burden of proof being imposed upon the accused, but it seems, certainly it hasn't been accepted, but on the other hand, it's never really been rejected, if I can put it that way, save in one case, which is a decision of the House of Lords, where, in fact, when you look at the decision carefully, even then it wasn't rejected.
I did take the opportunity yesterday to look at the current edition of Smith & Hogan.
Yes.
The editors say it has never been accepted in this jurisdiction.
Well, my lords...
Well, we haven't got there.
I think it's right, my lords. It's academic writers have said it doesn't appear to have been accepted, but on the other hand, you look at the people you look at the judgments, and they certainly seem to say it has been accepted.
But is your submission that it does exist in Trinidad, or it doesn't?
Yes, it would be. It does exist in Trinidad. If my lords, I fail on my... If it said these offences These are not offences of strict liability. Therefore, one must move to the opposite extreme. I say you don't move to the opposite extreme. This defence is the relevant one.
I mean, it's an essential part of your case, isn't it, that this can be treated as an offence of strict liability, that it is mitigated to that extent.
Yes.
So without that mitigation, you get into a silly position.
Well, my lords, there is a slightly tougher test, which is the lim chin aik test, which is it's open to the defendant to say he has done everything he could through himself and his agents and his servants to prevent the wrong thing happening. Now, if he can go that far, then he's off the hook on the face of it, even in relation to offences of strict
But
liability.
is your submission that is part of the law of Trinidad?
Yes, my lord, that is definitely part of the law, and my lords, I don't think there's been any issue on that. But I say that is the answer. Sorry.
Where do we find this, a decision in Trinidad that applies that principle?
My lords, I'm not sure, well, except of course in the Court of Appeal, in this case, they refer to lim chinaik, I think, approvingly. My lords, I'm not sure I can give you the answer to a specific Trinidadian case where lim chinaik has been accepted, but on the other hand, it's a fairly wide, I think it's right to say it's been widely accepted across the Commonwealth, in Australia, New Zealand, and indeed in England.
So there may be three categories, in fact. There may be
Yes.
lim chinaik, there may be sweet and parsley parlok diplock,
Yes.
and there may be the various possible defences arising from importation to protect the innocent stevedore.
Exactly, yes. Although perhaps that
Really,
last is an example of...
Fraley and Charlton.
Yes. Although that might be put into what you might call the lim chinaik exception, or the reasonable and honest mistake exception, or maybe all on its own. Right. My lord, this is the difficulty of dealing with things in the abstract. Sorry.
Yes, well, I rather thought that you were inviting us to think in the abstract, Mr. Knox.
No.
All that you want from us, if we accept your primary submission, is the acknowledgement that there may be a range of possible mitigations, shall we put it that way, rather than defences.
But they don't arise on the facts of this case. Right. That's what it comes to.
Not detracting from my Lord's point. Does the case law of the Court of Justice, the Caribbean Court of Justice, provide any assistance?
My lady, not so far as I'm aware. My lady, I did quite a bit of research, but I can't say I looked into that.
Well, we encourage counsel before the board to look into CCJ decisions, because obviously they may have considerable comparative value.
Yes.
But that's by way of general encouragement rather than particular to this case.
Yes,
Yes.
I think if some research were to be done, it would be quite useful to know if there is anything relevant to this point.
From the CCJ. My lord, just, well, perhaps we could afterwards put in a note to see if there is anything on the point.
Thank you.
Is that a convenient?
Yes, it is. We'll sit again at 2 o'clock. Court is now adjourned.